Welcome back to Lex Talks, legal topics simplified, where we like to, break down these complex legal concepts and make them easy to understand for you.
Yeah, and today we're going to be diving deep into some core principles of environmental law in India.
Um, Sometimes I feel like these principles, you hear about them and they almost sound a bit like lofty ideals, the kind of thing you'd read in a textbook, but not necessarily see actually playing out in a courtroom.
Well, that's where you might be surprised because these principles, things like sustainable development, the polluter pays principle, the precautionary principle, the public trust doctrine, they're not just theoretical concepts. They're actually deeply embedded in Indian law, and they're shaping legal decisions every single day.
Okay, so let's start with sustainable development, because it feels like everyone's using that term these days, but what's the actual legal weight behind it?
It's enshrined right in the Indian Constitution, Articles 48A and 51A to be exact. And basically, what these articles do is they highlight how environmental protection is woven into the very fabric of Indian law. And they emphasize the duty of both the state and the citizens to protect and improve the environment.
So it's not just some vague notion, it's a core legal principle.
Absolutely. And think of it this way, right? Imagine a company wants to build a new factory. Well, sustainable development means they can't just focus on profits. They have to consider the environmental and social impacts as well. So things like pollution control, resource management, the well-being of the communities where they operate.
So it's about finding that balance between economic growth and environmental protection.
Precisely. And India's commitment to sustainable development is evident in their environmental regulations and policies. And one really interesting example is the National Green Tribunal, which has been instrumental in enforcing environmental laws and holding polluters accountable.
Well, that's actually a perfect segue into our next principle, the polluter pays principle.
Yeah.
And I mean, it sounds pretty self-explanatory, but I'm guessing there's more to it than meets the eye.
You're absolutely right. The polluter pays principle goes beyond simply cleaning up a mess. It means that whoever is responsible for polluting the environment, they have to bear the costs of preventing further damage. They have to clean up the existing pollution, and they also have to compensate those affected by it.
So like if a company spills oil into a river, for example, they don't just have to, clean up the oil, they also have to restore the river to its original state and compensate the fishermen who, lost their livelihoods as a result.
That's exactly it. And it gets even more nuanced because the polluter pays principle isn't just about assigning blame after something bad happens. It's also about incentivizing companies to adopt cleaner practices from the get-go. Because if they know they'll be held liable for the full extent of the damage they cause, they're a lot more likely to invest in pollution prevention measures.
So it's a proactive approach, not just reactive.
Exactly. And this principle has been applied in some really landmark cases in India. One notable example is the 2025 Mahakumbh Mela case, where the National Green Tribunal issued an order to the pollution control boards and basically said, look, you have to ensure absolutely no sewage or waste is discharged into the Ganga and Yamuna rivers during the Kumbh Mela.
Wow, that's a massive event with millions of pilgrims. I can only imagine the potential for pollution there.
Exactly, and this proactive approach is a direct result of the polluter pays principle. The focus is shifting from simply reacting to pollution to preventing it in the first place.
Okay, so now let's talk about the precautionary principle. And I've always found this one a bit tricky to grasp.
Mm.
Could you break it down for me?
Of course. So think of it like this, right? If you're hiking in the woods and you come across a mushroom you've never seen before, do you just eat it?
Not unless I have a death wish.
Right. You'd want to be cautious. You'd probably err on the side of not eating it because you just don't know if it's poisonous. And the precautionary principle works in a similar way. It says that even if there's scientific uncertainty about the potential harm of an activity, if there's a risk of serious or irreversible damage, it's better to err on the side of caution and take preventative measures.
So it's about taking action even if we don't have all the answers.
Precisely. And this principle has had a significant impact on environmental law. Take the Taj Trapezium case, for instance. The Supreme Court ordered industries near the Taj Mahal to switch to cleaner fuels to protect the monument from pollution.
Oh, wasn't there a bit of debate about whether that pollution was actually harming the Taj Mahal?
There was, but the court, invoking the precautionary principle, decided it was better to be safe than sorry and protect this, iconic monument from potential damage.
So it's about prioritizing long-term protection over short-term gains, even if there's some scientific uncertainty.
Absolutely. The precautionary principle is about acknowledging that we don't always have complete knowledge about the long-term effects of our actions on the environment, and it encourages us to err on the side of caution.
Yeah, this last principle, the public trust doctrine, always sounds a bit like something out of a medieval legal text.
It does have ancient roots, but it's just as relevant today.
Yeah.
Basically, the public trust doctrine says that certain natural resources, things like air, water, coastlines, they're so essential to public welfare that they can't be privately owned.
So they're held in trust for the benefit of everyone.
Exactly. The government has a fiduciary duty to protect these resources for the benefit of current and future generations.
This brings to mind the MC Mehta v. Kamal Nath case, where a hotel tried to divert a river for its own use, and the Supreme Court stepped in.
You got it. The court upheld the public trust doctrine and said, look, this river can't be diverted for private gain. It belongs to the public. And this case is a prime example of how the public trust doctrine is used to protect these shared resources.
So the government can't just sell off natural resources to the highest bidder. They have an obligation to protect them for the benefit of everyone.
Precisely. And the scope of the public trust doctrine is continually evolving. It's now being used to address issues like climate change, arguing that the government has a duty to protect the atmosphere for future generations.
These principles are fascinating. I'm already seeing how they intertwine and work together to create this framework for environmental protection in India. But I'm curious, do these principles have any relevance outside of India?
That's a great question, and one we'll explore in detail in the next part. But for now, let's take a quick recap of what we've covered so far.
Okay, so we started by unpacking the concept of sustainable development, which, like you said, is enshrined in the Indian Constitution. And we talk about how it requires balancing economic growth with environmental and social considerations.
Then we explored the polluter pays principle, which holds polluters accountable for the full costs of their actions and incentivizes them to adopt cleaner practices.
We discussed the precautionary principle, which encourages taking preventative measures even in the face of scientific uncertainty, especially when there's a risk of serious or irreversible damage.
And finally, we touched upon the public trust doctrine, which protects essential natural resources from private ownership and ensures that they're held in trust for the benefit of the public.
This has been a really insightful deep dive so far. I'm eager to learn more about the global implications of these principles in the next part.
I'm excited to continue our exploration with you. Until then, keep thinking critically and stay curious.
All right, so let's pick up where we left off. You mentioned that these principles have relevance outside of India. I'm curious to see how they've influenced environmental law globally.
Well, you might be surprised to know that these principles are actually echoed in legal frameworks around the world. They've become cornerstones of international environmental law, shaping policies and legal decisions from, Europe to the Americas.
So it's not just India that's taking this holistic approach to environmental protection.
Not at all. Take the polluter pays principle, for instance. That's a widely recognized concept. Organizations like the OECD, the European Community, they've integrated it into their environmental policies.
So even those big international organizations are on board with holding polluters accountable.
Absolutely. And it makes sense from an economic standpoint, too. When polluters are forced to pay for the damage they cause, it creates a financial incentive for them to adopt cleaner practices.
Right, it's like internalizing the cost of pollution. If companies know they'll have to pay for the cleanup and any harm caused, they're more likely to invest in preventing pollution in the first place.
Precisely. And this can actually drive innovation because when faced with the potential costs of pollution, businesses are often motivated to develop and adopt cleaner technologies and more sustainable practices.
So it's a win-win for both the environment and the economy.
Exactly. Now let's look at the precautionary principle. The European Union, for instance, has really embraced this concept. It's embedded in their treaties, and it serves as a guiding principle for many of their environmental policies.
So it's not just a vague idea. It's actually law in the EU.
That's right, and they apply it to a wide range of issues, from regulating chemicals to assessing the risks of genetically modified organisms. The idea is to avoid potential harm even when there's some scientific uncertainty.
It sounds like they're taking a very proactive approach to environmental protection rather than waiting for problems to arise.
Exactly. And while there are, ongoing debates about the practical application of the precautionary principle, there's no doubt that it has significantly influenced environmental policy, not only in the EU, but globally.
It's interesting how these principles can evolve and adapt to different contexts.
Absolutely. Now let's shift gears and talk about the public trust doctrine. This principle actually has deep historical roots. You can trace it all the way back to Roman law.
Right, we talked about the idea that certain natural resources are inherently public and can't be privately owned.
And that concept has resonated across time and cultures in the United States, for example. The public trust doctrine has been used to protect things like navigable waterways and coastlines.
So the government can't just sell these resources off to private interests.
That's the idea. They have a duty to protect them for the benefit of everyone. It's like a legal safeguard against the privatization of resources that should belong to all citizens.
I can see how this principle is becoming even more relevant today with growing concerns about climate change.
You're right. Some legal scholars are arguing that the public trust doctrine should be expanded to include the atmosphere. They argue that governments have a fiduciary duty to protect the atmosphere from pollution and mitigate climate change for the benefit of present and future generations.
So it's about extending the idea of public trust to encompass the very air we breathe.
Precisely. It's a novel legal argument,
Mm-hmm.
but it shows how these principles are being reinterpreted and applied to address the pressing environmental challenges of our time.
Yeah, it seems like these principles are more than just static rules. They're dynamic concepts that can evolve and adapt to new situations.
That's a great observation. These principles provide a framework for thinking about our relationship with the environment in a holistic and sustainable way. They challenge us to consider the long-term consequences of our actions and to think about the rights of future generations, not just our own immediate needs.
This has been a really eye-opening discussion. So we've seen how these principles are shaping environmental law globally.
hmm
But how does this all connect back to our law students listening? Why should they care about these principles?
That's a crucial question for aspiring legal professionals. Understanding these principles is essential for a couple of reasons. First, it gives them a deeper understanding of environmental law, which is becoming increasingly important in today's world.
Right, because environmental issues are intertwined with so many other areas of law, from business and trade to human rights and international relations.
Exactly. Second, and perhaps more importantly, it equips them to be better advocates for environmental protection, no matter what area of law they choose to practice.
So it's not just about specializing in environmental law, it's about incorporating these values and principles into any legal practice.
Precisely, whether they're working on corporate law, human rights, even family law, understanding these principles can inform their approach and help them see the interconnectedness of environmental issues with other legal challenges.
It's about being a responsible and ethical lawyer, someone who understands the broader implications of their work and strives to use their legal skills to make a positive impact.
That's the ultimate goal, isn't it? To use our knowledge and skills to create a more just and sustainable world. And for law students, understanding these environmental law principles is a crucial step in that direction.
This has been a fascinating exploration of the global reach of these principles, but I'm also keen to see how they play out in the real world. Can we dive into some specific cases where these principles have been applied?
Absolutely. That's precisely what we'll be doing in the next part. We'll examine landmark judgments, recent developments, even some controversial decisions that highlight the complexities and challenges of applying these principles in practice.
Sounds intriguing. I'm ready to see how these principles come to life in the courtroom. All right, so let's get down to like the nitty-gritty. I'm ready to see how these principles we've been talking about actually play out in, real-world legal battles.
Well, get ready for some legal drama because there have been some cases that have truly shaped the landscape of environmental law, both in India and globally.
Okay, so let's start with a case we touched upon earlier, the MC Mehta v. Kamal Nath case.
Uh-huh.
The one where their hotel tried to divert a river for its own use.
Yeah, that case is a classic example of the public trust doctrine in action. The hotel owner essentially claimed ownership of a section of the river and, attempted to justify diverting the water for commercial use.
It's almost like they thought they could just, claim a piece of nature as their own.
Right, but the Supreme Court firmly disagreed. They applied the public trust doctrine, emphasizing that the government has a duty to protect natural resources for the benefit of all citizens, not just private interests.
So the hotel's argument that they could do whatever they wanted with the river because it flowed through their property that didn't hold water, so to speak.
Precisely, the court recognized the river as a public trust, something that needs to be preserved for present and future generations, and the hotel was ordered to restore the river to its original state.
That's a pretty clear message that messing with nature for private gain has consequences.
It was a landmark judgment that reinforced the power of the public trust doctrine to protect our shared natural heritage, and it really serves as a warning to anyone thinking they can exploit natural resources without considering the public good.
Now let's shift gears to a case that really put the polluter pays principle to the test, the Sterlite Industries case.
Ah, yes, this one was a major turning point in India. It involved a copper smelter plant in Tamil Nadu that was accused of causing widespread air and water pollution.
Yeah, I remember reading about this case. There were protests and concerns about the impact on people's health and the surrounding environment.
Exactly. The case went all the way to the Supreme Court, which ultimately ordered the permanent closure of the plant. They found Sterlite Industries responsible for significant environmental damage and ordered them to pay a hefty compensation of 100 crore rupees for environmental restoration.
Wow, that's a serious penalty. It shows that polluters can't just get away with damaging the environment without facing, substantial financial consequences.
It sent a strong message to industries across India and beyond. If you pollute, you will be held accountable. The costs can be significant both financially and reputationally.
It also highlights the importance of corporate accountability. Companies can't just prioritize profits at the expense of the environment and public health.
Yeah, let's talk about the precautionary principle in action. The Taj Trapezium case, which we've mentioned before, is a classic example.
Right, the one where industries near the Taj Mahal were ordered to switch to cleaner fuels to reduce pollution.
This case beautifully illustrates how the precautionary principle can be applied even when there's some scientific uncertainty. There were debates about the extent to which industrial emissions were impacting the Taj Mahal, but the court decided it was better to err on the side of caution.
So they basically said we can't wait for absolute proof when there's a risk of damaging this irreplaceable monument.
Precisely, they recognized the potential for irreversible damage and decided to take preventative measures. The court ordered industries in the area to switch to cleaner fuels, even if the scientific evidence wasn't fully conclusive.
It's a powerful example of how the precautionary principle can safeguard our cultural and natural heritage.
And it's important to remember that applying these principles isn't always straightforward. There are often complex factors to consider, and sometimes these cases raise some really challenging ethical and legal questions.
Yeah, for instance, in the case of the LG Polymers gas leak in Visakhapatnam, there were a lot of questions about responsibility and accountability. Was the company negligent in its safety practices? Did the government fail to adequately oversee the plant's operations?
That tragic incident really highlighted the complexities of balancing industrial development with the need to protect human health and the environment. The legal battles and investigations that followed explored whether the precautionary principle and other environmental laws were effectively applied.
It's a stark reminder that even with these principles in place, preventing environmental disasters and holding those responsible accountable can be a challenging process.
And it underscores the need for constant vigilance, strong enforcement mechanisms, and a commitment to continuous improvement in environmental regulations and corporate practices.
Well, these cases really paint a vivid picture of how these principles play out in the real world. They're not just, abstract ideas. They have the power to shape legal decisions, protect the environment, and hold polluters accountable.
And for you, as future legal professionals, understanding these principles and seeing how they've been applied in real-world cases is essential. They're tools you can use to advocate for a more just and sustainable future.
This deep dive has been incredibly insightful. We've gone from unpacking these core principles to seeing them in action in courtrooms, shaping environmental law and influencing decisions that impact us all.
As you continue your legal journey, remember these principles: sustainable development, the polluter pays principle, the precautionary principle, and the public trust doctrine. They're not just legal concepts, they're guiding principles for a more balanced and sustainable future.
Thank you for tuning into Lex Talks. We hope this deep dive has equipped you with a deeper understanding of these vital environmental law principles. Remember to subscribe and continue your legal journey with us.